legislation?
Yes, ma'am.
Okay, good. I sent one more this afternoon, one that I missed.
I did not get mine.
What does that
I only
mean?
got an email from today.
I only got an email today.
Okay, all the legislation was in it?
Let's see.
That's a data protection.
That's the one I just sent. I sent more of them last week.
No, mom.
That's the only one I got.
Hold
That's the
on.
one I got.
Hold on. Let me send an email right now. Okay. Okay. Hopefully I get an answer before we finish tonight. So last week when I was speaking to you all, I didn't feel too good. I just come back from vacation, not knowing that by Thursday, I had bronchitis. So I had to go on medication and I'm still on it. I don't know, because what happened is I got wet in the rain 3 times and I paid no attention to it. I started sneezing. I still paid no attention to it because I say, you always get wet in the rain, don't worry about it. But apparently all the time I was sneezing and walking about, all the cold was just dropping down on my chest. So if I sound a little hoarse and stuffy, that's why. All right. So we did quite a few pieces of the legislation that govern banking. And when you look at the pieces of legislation that govern banking, which we call the banking framework, it's best to understand how the law comes about. And that's why we have this section on the Bahamian legal system and general legal practices. It is for general knowledge. It depends on where you work in the bank. As you move up, you find out that there are normally amendments made to legislation. You'll also find out that there are new legislation being passed, or like the Banks and Trust Companies Regulations Act and the Central Bank Act, you will find where there are legislation that are repealed. So over time, legislation change, and it's very good to know the process that we go through and why the country does the things that it does. So the first question I have to ask you all is just a general question anybody can answer. To you, what is law? What does it mean to you? Don't read what's in the book. What is it to you as a lay person? What's law?
It's a
Good night, everyone.
Say it again.
There's a set of guidelines or laws to govern a body.
Mm-hmm. Anything else?
Law creates order.
Yes, it does. Similar to saying it's a body of guidelines. What else is there about law? There's a lot of talk in the papers now about law and changing laws. So you're still missing out on another part that has to do with law. What else is law? What else is law about?
I'll say a set of guidelines to go by. They can be that have offenses I mean, if not carried out properly, they have offenses and penalty.
Yes, but one thing is that law also looks at the custom, like what happens in society. So as society begins to change, the laws have to change. And you can see that happening now. A lot of laws on the books have to be changed. Some of it comes from the way in which we do things. Some of it comes from the way in which we look at other jurisdictions similar to ours and see the same cause and effect happening. All of these are a part of what is law. So we know we need it. Like Ellen said, it's to really it's to regulate the persons in the society and more or less to control them. So now my question to you is, do you think that the present laws on the books have this effect on society? Does it really regulate the rights and the duties of individuals in the Bahamas? And does it control them? Byron, you about to say something?
No, it doesn't,
Why? Why do you say that?
because our laws are so archaic that there are all type of loopholes and ways around them at this point. Any credible lawyer could get you out of anything in this town right now.
Mm-hmm. But being a part of the Commonwealth of Nations, why do you think it is that we have not tried to keep abreast with the changes based on other Commonwealth jurisdiction and other Caribbean jurisdiction, knowing that we face similar crimes, we're in similar businesses? Why is it that we have not tried to keep abreast of what's happening from a legal perspective?
Because everyone is benefiting from the way laws are now. Right? The high ups are of their hands and things, and the people are too lackadaisical to put pressure on them to affect change or agitate for change.
Okay, anybody else? You have a good point. Anybody else? No? So if you look at laws, the laws that are actually managed by certain ministries or certain industries, you can begin to see the difference in the way in which those parties actually review their laws and make changes to their laws. Can anyone give me any example of a ministry or an industry where the law is constantly, when I say constantly changing, I don't mean every 2 to 3 years. Because in law, constant is not something that happens in the snap of a finger. So constant could be in the last 20 years or 50 years.
I'd say the Ministry of Foreign Affairs.
What law have they recently changed?
Well, I know they're working on changing the law in regard to children being born to foreign parents, where they can take nationality of either parent.
Yeah.
And the past is only the father.
Now, you know, that's been on the table for years, right?
But, I mean, it's a change.
Is fighting again for a change. What other
Right.
change? What other change are they fighting for? What else? That's one.
Marital rate,
And what they want to do with marital rape?
I see the judge ruled in favor of, along the lines of there is no such thing as marital rape, but it seems as though it keeps popping up where women are agitating for it to be on the books, basically, marital rape to be a thing.
And so now what the Bahamas has to do is a couple of things. Because remember now, what law does? Regulates the rights and duties of individuals. So they have to look and see historically if there is an issue with rape in marriages. Then they're going to have to look across the jurisdiction in the Caribbean and see what they have done and what have been their incidences of rape in marriage. And then they're going to have to look across the Commonwealth jurisdiction to see what they have done and what incidences that they had that would have propelled them to make changes to their legislation to include marital rape. So it's not a simple, easy fix and you snap your finger and everybody make a bunch of noise. Because to change law requires a lot of thought, a lot of process, a lot of deliberation, a lot of discussion. Anybody else could think of a law?
I think the law is something about equal rights with the women and men.
And that one is based on treaties. And we'll talk about treaties in a little bit. So sometimes there are different forces that we actually have to entertain in order to bring our laws up to date. And of course, bringing our laws up to date, we have to consider whether or not it's a constitutional matter or not, and how it will impact society. So when we look at banking and look at the laws we discussed last week, you can see that banking itself has evolved over time. So at the very beginning, all they would have had was the Post Office Savings Bank, Royal Bank, and a few other offshore banks. Then time evolved. They got more offshore banks coming in, more commercial banks coming in. And they moved from that legislation in the 1965 suite of legislation for banking to the 2000. And in the 2000 is when they did a full sweep. They repealed that last legislation and put in a brand new piece of legislation, looking at the new dynamic landscape of the financial sector in the Bahamas. So now we come now from 2000 to 2020. And what they've done is repeal that piece of legislation and put in a brand new suite of legislation to regulate banks and trust company, and included in that credit union, money transmission business. They had earlier included private trust companies. So all of these are a part of being regulated under the Central Bank of the Bahamas. And the same thing was done for the suite of legislation that govern money laundering in the Bahamas and terrorism financing. And it came from twofold. One was the pressure from the international community. And the second one was saying that the Bahamas is not doing enough to address these offenses. So it was twofold. So it'll be the same way like how we're talking about equal rights. We have signed on to a treaty. Now, the international body is saying you've signed on. So when are you going to make the changes in law? So in the Bahamas, our legal system is made up of rules, the legal institutions, and of course, we have to look at the machinery, how we operate. And really, our whole legal system is all about regulating relationships. And you can always tell about relationship because there's always one party suing another party. Or it's the state suing someone else. So the Bahamas, as you know, was a former colony. And because we were a former colony, our legal system is based on English common law. And common law means that we follow a set of legal rules. And those rules are being established by judges. And that's how we settle disputes when you go to a court. So there are three primary types of law. You have public law, or private law, criminal law, civil law. Private law is more like when you go to the licensing authority to get a liquor license. The public law more or less is for the society as a whole. Private law is like banking law. Criminal law, you know, deals with societal behavior. And civil law is where individuals sue each other. And that could be for personal injury, or it could be because of a contract, or it could be because there is some mischief between the two parties and they want to sue on the grounds of tort. So legislation is law. And that law is made by Parliament. And that is to be found in the Acts of Parliament. And any regulations that is made. So when you go on internet, you go to lawsofthebahamas.gov.bs, and then you will see Acts of the Bahamas, and then you will see the regulation. And all of the laws of the Bahamas are listed there. So legislation itself has three main purposes. One is, like we've been saying, is to regulate and control society. The next one is to raise by taxation the financing that the government needs. And the third reason why we have legislation is either to create laws, repeal it, revise it, or reform it. So as a former colony, we have different sources of law, meaning where our laws came from. We know our law, English common law, from case laws out of Britain. We also know that our law also comes from the Constitution of the Bahamas, a document that every Bahamian should be in possession of and should have read. We also know that we get our source of law from Bahamian case law. Like how we just mentioned about the case that went before the court where the judge said that there is no marital rape in our legislation. Then, of course, law comes about by custom. How the individuals in society conduct themselves. Another source of law is international law and regional treaties. And so when members of parliament go to international meetings. In some instances, they are asked to discuss, present, and in some instances to sign on to treaties, and they're given a certain length of time to execute that treaty in their jurisdiction. And another source of law is equity, which means being just and fair. And that's what the judge carries out when he's making his decision. Any questions so far? No?
No.
Okay. So when we speak about common law, we have to talk about the doctrine of judicial precedent, which is case law. So case law is both legal law and is also historical law. And it's historical because it is linked to colonialization. So in common law, each case or judgment of the court builds on the principles that were stated in previous judgments. So central to this whole common law as a legal source is what we call the doctrine of precedent or stare decisis. The doctrine of judicial precedent proceeds on the assumption that where there are no appreciable statutes on a legal issue, the judge must look to case law. So in a particular matter, when we go through some of the cases, you will see how the judges would refer to earlier cases and rely on those earlier cases to make a decision. And these previously decided cases are what's called judicial precedents.
Ms. Archer,
Yeah.
all this information in the book?
Yes, ma'am.
Okay.
So you could always read the book afterwards. So when you talk about judicial precedents, there are two. One is binding and one is persuasive. The binding precedent is that the function of the judge is not to create law, but to decide the cases in conformity with existing rules. A persuasive precedent are those legal principles contained in judgments which merely offer guidance. So a decision made by the Court of Appeal in Trinidad and Tobago are persuasive. Decision of the Privy Council is binding. Because remember, the Privy Council is the highest court of our land. Now, whether a particular case is persuasive depends upon the factors of those cases. And the factors mean looking at the actual facts of the case, looking at the jurisdiction and the law itself, whether or not the law is similar to the law that's here in the Bahamas. And in some cases, it depends on who is the judge, who has given that decision. And that may carry some weight also as to whether or not that precedent is persuasive or not. So in the Bahamas, our judicature is based on the Privy Council being the highest court of the land. Then we have the Court of Appeal. Then we have the Supreme Court. We have the Magistrate Courts, and then we have other courts. So the Privy Council hears appeals from the Court of Appeals. And those are heard in England unless there's a special seating here in the Bahamas. So in the Bahamas itself, sitting in the Bahamas, the highest court is the Court of Appeal. And the Court of Appeal hears appeals from the Supreme Court and some from the Magistrate Court. The Court of Appeal, of course, has a president and 3 justices. The Supreme Court exercises what we call original jurisdiction. They hear civil matters, criminal matters, and constitutional matters, and they also have appellate jurisdiction. Criminal matters are instituted in the name of the Queen, but now that the Queen was buried yesterday, they'll be in the name of the King. And trials are heard by judge and jury. The Supreme Court is comprised of the Chief Justice, who is appointed by the Governor General on the recommendation of the Prime Minister after he consults with the leader of the opposition. The Supreme Court sits in New Providence and Freeport and can sit in any part of the Bahamas by notice or direct. And you know, the opening of the legal year is done in January. The Magistrate Court is the stipendiary and circuit magistrates, and you also have ex officio magistrates of the Bahamas. So the Magistrate Court is the primary court in the Bahamas. And what it does is it hears the criminal matters, for summary matters, and indictable offenses. And these courts in the Magistrate Court, they are also prima facie cases to determine whether there is sufficient evidence to proceed. So normally you'll see a matter goes to the Magistrate Court, and if they decide that there is sufficient evidence to proceed, then the Attorney General will issue a VBI, Voluntary Bill of Indictment, and goes straight to the Supreme Court. They also hear civil matters. They can also hear matters where the title to property is disputed and the value of the property doesn't exceed $200. Appeals from the Family Island administrators, civil and minor criminal convictions are also heard by the magistrate. So the stipendiary and circuit magistrate court is comprised of 17 magistrate courts. There are 14 courts in the Bahamas, in New Providence. There's 2 in Freeport, 1 in 8 Mile Rock, Grand Bahama. And of course, the stipendiary and circuit magistrate court is also of a specialized court, such as juvenile court, domestic court, and night court. Now, Family Island administrators and lay magistrates, they hear civil matters for very small amount, $400, and criminal matters of a less serious nature. Appeals from conviction or civil matters are made to the magistrate's court. So the question normally arises as to how one can identify the legal principle in an earlier decision. And there are different rules to look at. One is ratio de sedenti, which means the reason for deciding. And when you read cases, you begin to see what the ratio is. That is, what is the actual legal reason which the judge gives for making his decision. And when he does this, it looks at his decision consists of three things. His statement of what the facts are, his account of the way in which the decision was reached, and the decision the judge made to resolve the dispute between the parties. Another way you could look at it is you look at the decision or the comments being made by the judge that are what we call obiter dicta, which means by the way. So if he makes a statement which is not in fact exists or is not material, then it's called obiter dicta, by the way. Stare decisis means let the decision stand. Now also a judge, he has to be able to distinguish between binding precedents. And distinguishing binding precedents means that he has to, based on the facts, he then has to make a decision whether or not he's going to avoid the doctrine of being bound by decision that was made before. And for him to do that, he has to be able to say where there are differences in the facts, even though the law may be the same. He has to say, these are the difference in the facts, why I cannot be bound by the decision from a higher court. Now, whenever a judge is looking at making decisions and he's looking at the legislation, there are rules to statutory interpretation. So when you pick up your legislation and you start to read it, yes, it's in English, but there are rules on how you interpret the law. The first rule is the literal rule. And here what the judge does is he looks at the intention of Parliament from the act itself. So he, in his mind, he's looking at why did Parliament enact this piece of legislation? So if the words he's looking at are capable of only one meaning, then that's the meaning that the court will take and the statute will be enforced accordingly. Now, if he's looking at the legislation and he sees that if he takes that literal interpretation and it doesn't make any sense, or he says it's not going to give him the result that he don't think that the Parliament intended, or the statute is capable of more than one meaning, he's going to use the golden rule. If the statute that he is looking at is one that was legislated to remedy a mischief in the law, then he will use the mischief rule. And the last rule he will use is if there is a list of items that the legislation gives to explain a certain word, then he will use the justum generis rule, which gives a string of words to explain another word. And he will follow those words to come to a conclusion or meaning of a word. So with all of that said now, you know the Judicature of the Bahamas, Privy Council, Court of Appeal, Supreme Court, Magistrate Court, Family Island Administrators, Legislates. You know that as a former colony of the Bahamas, our laws came from England. And you know that besides coming from England, we had other sources of law, such as our Constitution, such as treaties we have signed on to, such as our own Bahamian law cases, and looking at our customs and our judges being trained in the Bahamas and in London, that they follow equity, being fair and being just. You know that once there is a higher court above each layer, the decisions that are made by the court above is binding on the court below. Unless, of course, the judge can distinguish that binding precedent. You know that the judge, when he's looking at a piece of legislation and he has to make a decision and he has to interpret what that legislation means, he has 4 rules that he can use to assist him in interpreting in what direction or what decision he needs to make. Any questions so far?
I have a question in relation to the binding and persuasive precedents. So with the binding precedents, that's like, I guess if one court is higher than the next, they could in turn like make a decision that would be like against what the other court said.
No, not that way.
Okay, so
That's an appeal. You're talking about an appeal. No. Binding is this. You go to the Supreme Court. And the Supreme Court said, looking at your matter, the Supreme Court says, in the court 10 years ago, there was a matter with similar facts, very close to your matter. And now the judge has to come and make his decision based on whatever contribution was made in your matter, and he's going to refer to the decision that was made 10 years ago. Now, based on the cases that was used 10 years ago to come to that decision, and because your case is on the same matter, and the facts are not far from the same facts, they're very similar, he is bound to follow those cases.
okay.
Yeah.
Thank you.
Mm-hmm. Now, hold on. Now, the point that you were making earlier is this. If you have a matter that's before the Supreme Court and you lose, and you decide that, guess what? I want to appeal this because I have sufficient grounds and I think I should have won, then you will go to the Court of Appeal.
Okay.
Yeah. All right.
Doctor,
Go ahead.
which island did you say housed a magistrate court? Because the book has incorrect numbers. You said it was 14 in New Providence, 2 in Grand Bahama, and 1 in.
8 Mile Rock.
Okay.
Yeah, make that change for me. I did it last night, so I updated that.
Sacha, there's one in Abaco too, eh? Yeah, that's a magistrate court in Abaco.
Not aware of that one.
Yes, Ms. Evans is a sitting magistrate there.
When that came in.
That's been a while back.
They didn't even mention that one in their report.
Yeah.
So that means we have 18 then.
Yes, ma'am, that's Magistrate Evans. She sits at that court in Abaco.
I didn't know that one. I've heard of it, but I thought he was in Grand Bahama.
No. No.
Okay, so that's 18 then.
But if we say 17 in our answer, we still right.
No, we've changed it now and everybody's listening.
Okay.
Yeah, but that's too easy. There's no question on how many courts in the Bahamas. No,
18, okay.
yeah, no. That question is just a giveaway. No.
Six.
Any more questions? No? Absolutely quiet, no question. Shanique, Sandy, Sydney, Vincent, Yolanda.
No question.
Wonderful.
No question.
Okay. So someone tell me, how does a bill become an act? Who can tell me?
We reading this or we have to like answer the question?
No, answer it out your head.
I think they have to read it in the House of Assembly. And I think they have to vote on it.
Bid?
And then
Did you say
Pardon?
bid? Did you say
No.
bid? BID?
no, ma'am. Like
Oh,
vote.
go ahead.
Like, vote on the bill.
Oh,
um,
vote. Okay.
Right. And then after they vote on it, I think they pass it to something else. I'm not too sure what happens afterwards.
Yeah. Okay. All right.
Yeah, so to touch on what Ms. Charlton said, I think they vote on it in the House of Assembly, and then it passed through the Senate, who I think approved it, and then I think the Governor General signs off on it, if I'm not mistaken.
Okay. So can someone tell me how a bill is introduced?
It is introduced by a member of parliament or,
Mhm.
right. It's introduced by them, and then a copy of the bill is given to the members of parliament, so when they come back again, they could have a debate,
Mhm.
and when they would have debated on it after the second time, I think it's read 3 times,
Yes.
right?
3 times. It's correct.
Then it
So,
goes,
how does that minister go about getting the approval to introduce that bill? He can't just pitch up and say he's introducing a bill. What does he do?
Consult the necessary bodies and create a draft.
Who's the necessary body now? That's not like a general term.
If it's in banking, you can consult banks, central bank, and then draft the bill and give it to the Attorney General.
Oh no, run that again.
I was saying if it's financial institutions, they would be like the banks. They would consult the banks or those that would affect in terms of the banks and other financial institutions. Consult them how that bill would affect them or the law, and then run it by the Attorney General.
But now when you say run it by, what that mean?
Well, give it to him so he can prepare and approve for a final draft.
You're going all the way to the end.
So once a draft is done, that has to go to Parliament first. The first draft.
No, it goes to the the general, the AG's office for vetting. But before you
Oh.
even that point, if you're talking about changes from the legal framework versus any other piece of legislation, because don't forget now, in certain quasi-government institutions, they have an in-house counsel. That's different from ministries that don't have one. So if you're going to, let's say we look at the new suite of financial legislation, the Central Bank Act and the Banks and Trust Companies Regulations Act, whatever changes that had to be made, a memorandum had to be prepared on what are the proposed changes to the legislation, and then ask for approval for a bill to be drafted. You can't just do it on your own. If it is agreed that the bill should be drafted, then that memorandum is initialed and is sent to the secretary to the cabinet to be approved. The cabinet then looks at the memorandum and it decides, and they make a decision based on policy. And based on policy means they look at their legislative agenda and whether or not that piece of legislation is a priority. Then the secretary to the cabinet would then go to the ministry and to the AG's office for information. Then the instruction is given to start drafting the legislation. And those instructions could also speak to the language that the legislation should be written in. Now, depends on that piece of legislation. The Prime Minister could also have a committee that oversees that legislation because it may impact other policy decisions. And so the Prime Minister or that committee could give instructions to the Director of Legal Affairs on things that should be communicated or changed within that bill. So the legal department in the central bank would then begin to draft that document in conjunction with the Director of Legal Affairs. Now, once the central bank has drafted it, it's being reviewed by Director of Legal Affairs, then copies are then made for cabinet. The minister responsible will then put the bill to cabinet with a memorandum explaining and commenting on it. And attached to that would be a cabinet memorandum to the secretary and the cabinet with copies of the bill for circulation. Now, if the bill is long, again, cabinet can refer it to a committee. And the committee could come back and make recommendation. And the recommendations can be presented to cabinet. And any amendments needed to the legislation goes to the Director of Legal Affairs. Any changes that need to be made then goes back through the Director of Legal Affairs. Once the amendments are made, then the minister responsible will put the subject back to cabinet according to the procedures. If the amendments aren't major, then the bill will not be put back to cabinet. They will normally just proceed with the bill without further reference to cabinet. So now when cabinet approves the bill with or without amendments, then they authorize the minister to introduce that bill to Parliament. So once the bill has been approved, then they arrange for it to be photocopied, so the copies can go to the members of Parliament when the bill is introduced. And the secretary to the cabinet then sends out copies of the bill for printing and first reading to Parliament. The minister himself for that bill signs the copy of the bill. And if he isn't present, another member of cabinet will do it. Now, if the bill is short, they don't go through that long process. So if it is short, all the minister does is, before he consults with cabinet, he invites the Director of Legal Affairs to review the draft. And if there's no difficulty with it, then he prepared a draft bill with the objects and the reasons. And then the minister presents the bill to cabinet, along with a memorandum. Now, once we've gone through the 3 readings, what happens after that?
They send the bill to
Cabinet,
No, that's the cabinet. Now, after going through the 3 readings, it goes to the Senate.
Senate, to the Senate, right.
to
Goes
vote on
to,
it.
and then the Senate debates it.
Mhm.
And the majority of the senators are in favor, then the bill is passed. But it's still not finished yet.
Have to be signed by the Governor General.
That's right. So it needs an assent. And then after the assent, it needs what? It has to be published.
Gazette,
Yes, gazetted. It has to be published to become law. And that's the process. And you can see from the laws that you all mentioned earlier and other legislation that they're discussing that it is not a quick fix. Because you don't write a law today and change it tomorrow. It's a lot of work involved, a lot of decisions to be made. And each member of Parliament has to give their input. as to how it will impact their community. And how it's supposed to work is that they should be having town meetings with their community to discuss these bills and to get their feedback and take it back to the House. So it shouldn't be a matter whereby the member of parliament just brings comments on his own or just from his inner circle. It should be from his community. Any comments? No? I don't hear any. No questions.
No, man.
Okay, wonderful. Look like I'm gonna get a midterm with all A's. That's how it looks. That's how it sounds. All right, let's move on to chapter 3. Remember I said last class we will begin, right? Yes.
Yes, ma'am.
Okay, all right. So remember I said to you all last week that a banking relationship is based on contract law. So that means that whatever you do in a bank as a customer or as the institution itself, everything is based on the contracts that were signed between the bank and the customer. So to come to that conclusion and to work with that relationship, you have to know what is a contract. And a contract is a legally enforceable agreement, and it gives rise to obligations. Any contract you sign, you'll see there are obligations on behalf of either parties to that agreement. So under contract, the parties voluntarily assume their obligations or undertaking. So let's say you have decided that you like a particular car and you want to purchase that car. What's the steps you take? Anybody, what's the steps you take?
Question, please.
If you see a car you like
Mhm.
and you want to purchase that car, what are the steps that you take?
You would first inquire about the price. You would ask them the asking price. I guess being a typical Bahamian, you can try talk them down. After you would come to an agreement on the price in which they're going to sell you the car, the person selling the car would, I guess, come up with a bill of sale. And I guess wherever you decide to meet, you would meet the person, they give you the bill of sale. Or at least no, before that, you would look at the car to make sure everything is up to par before you purchase. And then the person selling the car would give you the bill of sale, you give them the funds. And yeah.
Okay, so let me ask someone then. When you before you sign that bill of sale, so you look at the car, you test drive it, you say, yes, I want it, I want that. What is that? What are you doing at that time?
That's a verbal agreement.
Sales agreement.
And then after you've done that, you now decide that yes, you want to buy it. You chew them down a little bit. and you say, yes, I'll buy it, and I'm not buying it for 2,000, I'll buy it from you for 1,500. And then they agree. What's that?
Negotiation.
It's an
Start-
agreement.
Right, you start negotiating. And then you sign the bill of lading. And then you hand over the money.
Right.
Okay, and then you pull off and you get your car insured and licensed. Correct?
Yes.
Okay, so all of that comes under contract law. All of that. So to have a valid contract, and notice the word valid before it, not just contract. To have a valid contract, you need an offer. And you need acceptance. Someone has to make an offer, someone has to accept. The third thing is you must have consideration. Consideration is money or performance of an act. Fourth, you must have the intention to create legal relations, which means that both parties must be in the same mindset to say, yes, I want to buy, yes, I want to sell. And then the fifth thing is that both parties must have the legal capacity to enter into that contract. Now, in addition to all of those things for a valid contract, there are other essential things, and that those other essential things depends on the type of contract. Some contracts must be in writing, not all. So if that was a verbal contract, and let's just say he was selling it for 1,800, you agreed 1,500. And then he tells you, no, I didn't agree 1,500. We had agreed for 1,700. What are you going to do? Because it's not in writing. It's your word against his word, correct?
Right.
So another thing you have to think about is legality. The contract can't be against public policy. So that means that you cannot sell something that is illegal, nor can you sell something that is not your own. Then you have to look at the consent to the terms of the contract. You have to make sure that the terms have not been misrepresented, or that one person isn't trying to influence the other person in the contract. And of course, when you talk about a contract being valid, it means that it has to be enforceable by law. So you and I cannot enter into a contract to sell drugs, because one is against the law. Two, you cannot enter into a contract for something that is illegal. Depends on the contract. The terms of those contracts have to be very clear. And the contract has to speak to the responsibilities of both parties. Has to talk about the obligations and have to talk about the duties. And of course, have to talk about legal liabilities. In the event that either party wants to terminate the contract, within the terms, there should be a provision for discharge. And of course, with any contract, there are remedies. Remedies if one of the parties doesn't perform. Remedy if the contract itself is frustrated. being mindful that only parties to the contract can enforce the contract. And of course, there's a limitation, a time frame in which you can bring action. So let's look at offer. What is an offer? An offer is one person proposing to another or promising to another that they will enter into a contract. Now, when they do that, they must have the intention to be bound. So it's like when you walk in the mall and you look in the window and you see a dress or a suit, and then you look at the price. That price is to draw you into the shop. Sometimes you don't notice that people say, I don't have that exact one, but I have one that is similar to it. So the one in the window is for $40, but the one that I have that is similar to it, but with a better quality, it's for $80. So the exhibit in the window was what we call an invitation to treat. It is not an offer. So an offer could be made to an individual, or it could maybe be made to a group of persons. An offer could be oral, it could be written, and it could be implied by conduct. So in contract law, the person making the offer is called the offeror, and the person to whom the offer is made is called the offeree. So there are times when it is difficult to extinguish between an invitation to treat and an actual offer. So like I said, an invitation to treat is like a negotiation, inviting you to come in. But it's not saying that that person is willing to be bound. So what you really look at between an offer and an invitation to treat is whether or not, based on the communication between the parties, is whether or not it was their intention to be bound. So an offer can be revoked at any time. However, the revocation must be communicated to the offeree. The offeror can revoke the offer by himself, or he can revoke the offer via his agent. Now, you can make an offer, and let's just say this offer is open until Thursday. After that time, the offer lapses. If no time has been set in the offer expires after a reasonable time. And that depends on how the offer was made and the nature of the offer. If the offeror or the offeree dies before the offer is accepted, the notice of death terminates the offer. Now, if an offer is made and the offer is rejected, the offer no longer can be accepted. The same way, like I said, if the person is selling the car for 1,800 and now you're saying it's for 1,700, then that is called a counter offer. And of course, like I said earlier, an offer may be made to the public. So that's to the wider public, saying if you come and try this product, we'll pay you $50. Any questions so far?
No, ma'am.
No? You're gonna have homework on this now.
I am done.
You know that, right?
No, ma'am.
Yeah, I have homework.
I even know, I don't have a book. Yeah,
You know a book yet?
no, ma'am.
Neither do I. I'm in Apico, still waiting on my book to be delivered.
So that's Ellen and Yolanda, right?
Yes.
Yes.
Hold on. I'm sending another email.
I should have my book by Thursday. It's gonna be placed on the boat tomorrow, I was told.
I think they said today too, mine was delivered to Bahamas Mortgage Office in Nassau, so
Okay. We'll see.
they will have our books.
You'll have it in time to do your homework.
Okay.
I'm just sending a note.
Okay.
Just to make sure, let them know that you all are looking for it. Okay, but I'm gonna give you some homework because what I want you to understand is the basic concept of contract law. Because when we leave contract, we go into banking law. And banking law is based on contracts. Every agreement that you have with a customer in banking is based on contract. But the principles that you use will be banking law. And I know sometimes students start to get confused. So acceptance. Acceptance means that you have made a declaration that yes, I accept your offer. So, but in order to accept an offer, that offer must still be open. It can't be closed. So sometimes, if you're in lending, let's say you have agreed that you're going to extend a facility to a particular client, and then you put that this is open until. That's an offer. Once that date is passed, that offer is closed. They cannot come after that date to say, oh, well, I wasn't here. Can you still offer me that interest rate? No, that offer is gone. The time has passed. So acceptance must be unequivocal, absolute, unqualified, and clear in its expression. You don't need someone saying they accept, and then they say, but I'm not too sure. I may have to think about it, but no, I think I could take it. No, that is not acceptance. And no condition must be attached to the acceptance of an offer. And it cannot be considered a counteroffer. And of course, acceptance can be by word or it can be by conduct. So let's just say, if I say, I'm going to offer you $100 to clean my yard. That's how much I'm going to pay you. I need it done by Thursday. If I come home on Wednesday and my yard is already done, what's going to happen?
And the offer wouldn't be there anymore because you don't need the person in the yard.
Why? No, the person cleaned it. The person came and said, "Can I clean your yard?" And I said, "Yes. I'll pay you $100, but it needs to be cleaned by Thursday. And when is
Oh,
my yard is clean?"
mhm. So you have $100 for that person.
Yes, you do. You can at that point now ask the offeror, say, "Well, I only paying you 75. Bahamians love to do that. You made an offer and they accepted by conduct. Now, acceptance must be communicated to the offeror. So he has to be informed and notified. So let's just say in that instance, you saw the person out there cleaning your yard. They said good morning to you when they came. They even came onto the door and asked for a cup of water. Wouldn't you say by conduct, they have communicated that they have accepted your offer by their act?
Yeah.
Yes.
Okay. So there are two exceptions to this rule. Where the offeror sets out his own method for communication of acceptance. And the second one is the postal rule applies. And the postal rule is where the parties have agreed or indicated the use of the post as a means of communicating. Of course, you know, now it's by email. Some companies still use registered mail. And so they actually will be saying how you should be communicating. And the postal rule applies to faxes, emails, but not telegrams. So we spoke about acceptance. We spoke about offer. Now there is consideration. Consideration is money or kind. It can either be given, promise, or something is done in exchange, like barter. Each party to the contract undertakes to discharge some legal obligation under the contract. And each exchange that they have agreed to has a value. A gift is not consideration. So past consideration is not consideration. Consideration is here and now. In law, something that you did before or something you gave before is not consideration. If the person promises to perform an existing duty or obligation to the promise, or a promise made to a third party, cannot work either because they are not a part of the contract. Also be mindful for consideration that gifts of natural love and affection has no monetary value. However, a promise freely made can be used as a defense to vary an existing contract if that promise has been acted upon by both parties. Intention to create legal relations. That's looking at the minds of the parties to the contract. Both parties must have in their minds agreed that we are entering into a contract to buy or to sell this vehicle. at this price. Now, if you have a social arrangement, or you have an arrangement with your husband, or arrangement with your sister, or arrangement with your brother, those are not to be considered as having an indication of an intention to create legal relations because they are domestic. There are certain contracts that must be in writing. And that mandatory authorization of certain contracts being in writing has to do with fraud. And one of those are conveyances and mortgages. They must be in writing. Now, to enter into any contract, you must have capacity. And capacity means that you must have the legal capacity. That means having a sound mind to enter into a contract. And you must also have the authority to enter into a contract. And if you're acting as someone's agent, then you must have the authority and the power to enter into a contract. Now, when you have a minor, someone under the age of 18, and a person who is mentally incapacitated and drunks, they have restricted capacity. So let's look at a minor, someone under the age of 18. If that person under the age of 18 is used to a certain lifestyle and they enter into a contract, let's say to purchase, I don't know, a little moped, something that they know in their lifestyle is something that their parents would have bought for them and they need it in order to get around in town. They can enter into a contract because to them, that is a necessity, something that they need for everyday living. And that contract by that minor is enforceable by the minor and by the party in which he does, or whomever he does business with. Any other contract that a minor enters into is voidable. So be mindful that a minor can enter into a contract for what we call necessaries. That's food, clothing, accommodation, education, apprenticeship, and any other beneficial contract. Now, a person of unsound mind, if a person is certified as being incapable of dealing with his property, then in most cases, his legal affairs are delegated to a representative. And that representative can make a contract on his behalf. Now, you have some cases where some people are mentally disturbed, but they're not certified. And any contract that they enter into would be similar to a contract entered into by a minor. which means that if they entered into a contract for necessaries, remember, which is food, clothing, or accommodation, then those are enforceable against that mentally disturbed person. It's binding on them. Any other contract that that mentally disturbed person enters into can be repudiated by the mentally disturbed person. And repudiation means that that contract itself can be made void because, number one, the other party knew that that mentally disturbed person had a disorder, or based on the mental disorder, it meant that that affected person was unaware of the effect of the contract. So let's look at persons who are drunk. If the person is so drunk and they don't understand anything, including the contract, and the other person knew this, that drunk person, when he becomes sober, he could apply to have that contract set aside. But if he decides when he is sober that he wants to ratify that contract, then he's going to be bound. And he's going to have to pay a reasonable price for necessaries. Now, when you speak about capacity, again, you have to think about another group of persons, and that's corporations. So a corporation, you have to look at the statutory documents for corporations, which means you have to look at the memorandum of association and articles of association. And then you have to see the purpose for which the company was incorporated. Additionally, you have to know who is authorized to act on behalf of the company. So it depends on the contract. You have to be able to know what contract requires board approval, what contract requires management approval. So all of these things you have to be aware of when you're dealing with a company. In addition to that, you need to know whether or not that company is in good standing with the registrar general before you do business. So it's quite a few steps you have to look into before you enter into a contract with a company. Any questions? No? All right, I'm thinking of a question now because you have to do some homework. All right. Should I type it out and send it, or you want it now? Because sometimes you get it late. Which one is easier?
You could actually do both.
Okay, I'll do both then. All right, let's go. Consider the rights and liabilities Consider the rights and liabilities of Jermaine. Consider the rights and liabilities of Jermaine, who is 17, in respect of the following transactions. One, he bought a pair of cufflinks. He bought a pair of cufflinks costing $500. From Elvis. But he hasn't paid for them. He bought a pair of cufflinks costing $500 from Elvis, but he hasn't paid for it. 2, he bought an exercise bike. He bought an exercise bike from Kenneth and paid for it. He bought an exercise bike from Kenneth and paid for it. But he has decided that exercise is a waste of time. He has decided that exercise is a waste of time and he wants his money back. And third one, Jermaine has agreed to work as an assistant in Cycles Unlimited. Shop.
Mr. Archer, could you start the third one over again for me, please?
Okay, Jermaine has agreed to work as an assistant in Cycles Unlimited shop. But left after 1 week. But left after 1 week. Because the hours were too long.
And he knew the hours were too long prior to agreeing to it or not.
That's what you can argue.
Okay.
Okay. So the contract with Cycles Unlimited. The contract with Cycles Unlimited provided that it could only be terminated by 6 months' notice on either side. You can get started on that one. I'll be sending you 2 questions. Okay?
He's sending 2 additional questions other than these 3 questions, is what you're saying?
In addition to those 3 makes 1 question. I'll
Okay,
be sending the other one.
these 3 questions. Okay.
Yeah, those 3 is just dealing with just Jermaine. Then I'm gonna send you another question. And depends on how I feel when I write that tomorrow. I may add a third one since I heard you say 3. Oh, I love it.
Apologies,
Said
Mr.
3. No, we didn't say 3. We was in asking if you were just gonna reiterate the same questions, which was 1 and 2, and you're telling us to work on the third part of the
Ah,
question. However, I'll suffice for 1 question extra other than this one that you gave us.
you sure?
Positive.
It stimulates the brain.
Yeah, but my brain done stimulated enough for the day. Right now, my
Okay.
brain's smoking. I need some ice.
Oh, Lord. All right. So next class, we're going to do the homework and we're going to finish the chapter looking at discharge, remedies, and let me see if I want to start. No, I have something else I need to discuss. Yeah, what I'll do, I'm going to send you 3 questions. 2 is homework. 1 we will do in class together. How's that?
Okay.
That's fine.
Okay.
That's better than 3 for homework. I could wait
That
for that.
sounds okay.
Gotcha.
2 for homework and 1 we'll actually discuss in class.
So one of them we discussing in the next session, right? Or the
Yeah.
session.
Uh-huh. We're gonna do
Okay.
the 3. We're gonna do the 3 of them in the next session.
Okay.
But 2 of them, I want you all to be talking to me, telling me how
Okay.
what you came up with, and then
Okay, I get
third one, which you will also have. If you want to attempt, you can. But I'm going to direct you as to how you should approach a question.
okay.
Okay. And so when
Apologies.
I tell you how you should approach it, then you need to keep that in mind for when you answer your exam questions. But right for now, I need to see how your brain is thinking.
Excuse me, Mr. Archer.
Yes.
Apologies. I was at technical issues a second ago.
Okay.
How are we to address this question? Because I wrote down everything you said just now about Jermaine. From what standpoint are we arguing or
Contract law.
contract law? Thank you.
This is just simple contract law.
So we're looking at it from the aspect of a lawyer, of a judge,
No, just a regular person.
just a regular person, and
Uh-huh.
giving you an unbiased opinion. Thank you.
Yeah. So you're going to use the principles what we just went through tonight.
Thank you.
Okay. Because remember, we just finished speaking about minors and what kind of contract a minor can enter into. So you need to look at it. You need to tell me whether or not he can enter into these, whether they're legally binding or not.
Okay.
And then I'm going to give you another question for you to tackle. And then there'll be a third question. And we'll do the 3 of those next week, Tuesday, and finish up this chapter.
So, Ms. Archer, question.
ahead.
So, for clarity, so for this the homework that we're about to do, like, there's no right or wrong way to do it, seeing that we are not sure, like, how we really approaching it. We just doing it for practice.
You're just doing it for practice. I just need to see the understand contract law. After you
Okay.
finish that, and we
That's
do
from the
the
same.
one, when you finish those 2, and we go to the third one, I will begin to tell you what's the right way to do it. Okay? So don't hurt your head much. I just
Okay. Thank
talking. And then when we get to the third contract question to next week, Tuesday night, I want you to then clear your mind and begin to think in the way in which I'm going to show you how you should answer a question. Okay? So if you get frustrated, or you can't figure out what your answer should be, don't worry. But come for class to discuss it, and say where you were having issues, what you didn't understand, or this is how I was thinking. This is what I would have said. This is what I would have done. And then when we get to the third one, I'm going to tell you how to answer a contract question. And that'll be whether your contract or that will be in banking law. It will follow the same format. Okay. Yep. No questions?
Excuse me, Ms. Archer. I know you were saying that you're sending the homework by email. Did you receive the email I would have sent for the update of mine?
Yes, I did.
Okay.
Yeah. I did. I did send it. I need you all to make an attempt. If you feel like it, if you write it out, you can scan it to me, or if you type it out, you can send it to me if you wish. So I can have a look at it and see. Okay? So I won't give you all too much headache. Headache will start after the next class, when we start the banker-customer relationship. All right?
Basically, what you're saying is there isn't even no headache yet then.
No, there's no headache.
So I need to go to the clinic then.
There is no headache yet because we haven't begun our banking principles as yet. Okay?
Okay.
All right. So look out for your 3 questions, and then we'll go from there next week, Tuesday. Just be prepared. All right? Okay. Everybody have a good evening. Read over again if you have to. If you have questions, you can shoot me an email. All right?
Okay.
Okay.
Good night.
Good night.
Good night.
Good night.
Good night, good night.
Good night. Ferguson.